I'm calling Carmel Cipollone.
Mr Chair, I've got a few different queries about part 2 of this bill, and I'm going to start right at the beginning here where it says a returning offender is a person who has been convicted in an overseas jurisdiction. And I won't even continue with that because I just want clarification from the Minister about what constitutes an overseas jurisdiction, because I notice in part 1 that it says, it defines it. It says overseas jurisdiction A excludes the islands and territories within the realm of New Zealand, but B includes the self-governing state of the Cook Islands, the self-governing state of Niue, Tokelau and Ross Dependency. And I'm just a little bit confused because I thought that those were the only islands that made up the realm of New Zealand, Mr Chair. So I'm wondering whether the Minister can clarify that for us. So just again to repeat that, overseas jurisdiction, that definition is a bit confusing because A says excludes the islands and territories within the realm of New Zealand, but B includes the self-governing state.
We're on part 2.
Yep, Mr Chair, I'm relating it to the fact that a person who is a returning offender in part 2 is someone who's been convicted in an overseas jurisdiction, and so I'm just talking about what the definition of overseas jurisdiction is there. But I'll leave that to the Minister to ponder, and it would be great if she could respond, because as I'm sure she could imagine, we're all a little bit confused by that. Mr Chair, I just want to get clarity around what happens with these offenders when they're returned to New Zealand. So it does say that a returning offender is a person who's been convicted in an overseas jurisdiction of an offence for conduct that constitutes an imprisonable offence in New Zealand and being liable for deportation or removal as a result of that conviction. So looking at that, initially I'm thinking they have been deported, but are we saying here that they might not necessarily have been deported, they may just have been liable for deportation? Because if they had been deported, then I'd assume that they would be met at the airport by someone here to take over from whoever's escorted them back to New Zealand. And in that instance, I would think that the identifying particulars that are also talked about in part 2 could then be gathered at that point, rather than leaving it to potentially sometime within the 6 months, the first 6 months that they are back in New Zealand. Mr Chair, and on that subject, just in terms of being able to gather those identifying particulars within the first 6 months after the offender is returned to New Zealand, I just want clarification from the Minister around what circumstances it would be appropriate for the police to detain that returning offender. So would that be because they had been taken in under some other charges, or they'd come under the watch or notice of the police because of some other potential criminal activity? Or could they just be informed of the fact that this person was a returning offender and then just show up to their house or their place of work or a mall on the street where they perhaps were, and then detain them at that point, Mr Chair? I guess I'm just trying to work out what the appropriateness of detaining these people within the first 6 months of them returning New Zealand to New Zealand might be. Mr Chair, looking at further down where we see storage on police information recording system of identifying particulars, there's one bit that's a little bit concerning because it says, however, photographs or visual images of a returning offender and impressions of that person's fingerprints, palm prints or footprints that are provided in response to a request under Section 9 or obtained under Section 11 in error must be destroyed as soon as practicable. So I want to know what situations the Minister envisages where someone's identifying particulars might be taken in error, because this is really specific to returning offenders. So are we saying that there is the potential here for someone to be identified as a returning offender and actually that being mistaken identity, in which case that's why this particular clause is in here to cover off that particular scenario? And I just guess I'd like to know from the Minister whether or not there's been situations in the past where these types of things have arisen, or whether she can envisage that as being a potential problem down the track. I guess, especially in light of the fact that there is a 6-month period to gather that information. So are we going to potentially see people who aren't returning offenders? Mr Chair?
Ko Dennis O'Rourke.
I guess I was taking